and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Clark Neily, Vice President for Criminal Justice at the Cato Institute. We will discuss his article, Jury Empowerment as an Antidote to Coercive Plea Bargaining, which is published in the Federal Sentencing Reporter, as well as his work on criminal justice reform. So welcome to the show, Clark.
Thanks so much. It's a pleasure to be with you.
Yeah, I'm really glad to have you on. As you know, I've been following your work for a long time with Institute of Justice and now with the Cato Institute. And I've always admired your commitment to criminal justice related issues and reform in that area. And it was a real pleasure to read this new and very provocative and in some ways, I think a little bit surprising article.
Thanks.
So for listeners who might not be so familiar with criminal justice related issues, I wonder if you could start by talking a little bit about why plea bargaining is so common, right? I mean, we have this idea that when people are charged with a crime, there's a trial and the jury deliberates, et cetera, kind of 12 Angry Men type vision of the criminal justice system. But it seems like that's not really what's going on most of the time.
Well, that's exactly right. There are two ways, basically, to adjudicate criminal charges, at least in this country. One is the constitutionally prescribed mechanism of a jury trial before 12 citizens drawn from your community. The other way is for a person to simply plead guilty and void the trial, essentially waive their right to a trial and just plead guilty. And that has become the dominant mechanism for adjudicating criminal charges in America today, the plea bargain. In fact, about 95% of all criminal convictions today are obtained through a guilty plea by the defendant. So virtually everybody waives their right to a jury trial. I think this is very concerning for a number of reasons. First, plea bargaining was completely unknown at the founding. It really didn't sort of start to gain traction until the 1800s and really in most places until well into the late 1800s or even the 1900s. Initially, courts tended to look very skeptically at plea bargaining. One court even described it as really no different in substance from justice for sale. And sometime in the last maybe 50, 60 years, the judiciary has really just pulled a complete U-turn and has fully embraced plea bargaining as not only a legitimate, but indeed a necessary feature of the modern criminal justice system, and one without which, frankly, the criminal justice system could barely function. I'm not sure if that's true or not, but that's the perception of the courts. And so effectively, plea bargaining has virtually eliminated the constitutionally prescribed citizen jury trial, and I think that's deeply problematic.
So why did that happen? I mean, if plea bargaining was seen as sort of uncommon or even distasteful for such a long period of time, what changed to make it seem like it was appropriate or even sort of obligatory or desirable?
Well, plea bargaining has a number of features that make it extraordinarily attractive for the government and particularly for prosecutors. Compared to a jury trial, plea bargaining is much less expensive. It's much more convenient. Prosecutors can obtain far greater number of convictions through plea bargaining than they can through jury trials, again, which tend to be time-consuming and expensive. But perhaps the most attractive feature from a prosecutor's standpoint is that plea bargaining is certain, whereas jury trials are risky. And so prosecutors have, as we'll get to no doubt later in the show, figured out how to deploy a number of extraordinarily powerful levers that, when applied in combination, have proven successful in getting virtually all criminal defendants, or not every single one, but the vast majority of criminal defendants to forego their right to a jury trial and simply confess their own guilt. That strikes me as extraordinarily concerning. The history is replete with regimes that have excelled in the extraction of confessions from their own citizens. It's not a good club. It's not one that you want to be a member of, and we are very much a member of that club.
Well, were there particular legal or social or institutional changes that made plea bargaining sort of the default rather than the exception? Like, did something have to shift in our sort of legal system in order to make that possible? Or was it just kind of a gradual change over time?
Yeah, there's been interesting speculation about that. So Judge Stefanos Bibas has written about this, and as have others. I would say there's at least three things that people have sort of flagged. One is the rise of a kind of professional prosecutor and criminal defense class, so that instead of the old days where this is much more sort of happenstance and sporadic, you've got the same people doing the same jobs, encountering the same people on the other side of these cases, so they get to know each other. They get a sense of kind of how the cases are likely to play out. It just becomes a lot easier for them to, sort of negotiate potential outcomes. As for judges, there's some speculation that, or maybe not speculation, I should say, some history that indicates that around the time of the Industrial Revolution, judges' dockets began filling up with tort cases for cases involving workplace injuries and things like that, and judges began to have less and less time to devote to their criminal docket, and were more and more interested in more efficient ways of resolving criminal cases on those dockets. And then a further argument is that the crime rate began increasing, and that there are a number of factors that might explain that. But you've got a combination of alcohol prohibition from 1920 to 1933, increasing immigration, urbanization, and so forth. And so the argument is that, in essence, judges sort of started to feel overwhelmed by this combination of an increasing civil docket on the one hand, an increasing crime rate on the other, and these pressures, arguably, and some have theorized, led all of the major players in the criminal justice system to sort of come together and displace the jury trial with plea bargaining as the default mechanism for resolving criminal charges, as it is now and remains.
So, why is it then that defendants agree to plea bargains rather than going to trial? I mean, is it beneficial for defendants, or are there institutional features that enable plea bargaining to be used in ways that might be unfair to criminal defendants?
This is one of the most important questions, I think, in all of criminal justice, and there are two radically different takes about this. On the one hand, if you talk to people who support the current system, and certainly most prosecutors do, what they will say is that criminal defendants are simply being given a benefit for sparing the state the expense of and inconvenience of a full-blown jury trial when there would be no point. So you commit, a crime, let's say a burglary, you're looking at 5 years. It's a bit of a hassle for the government to do all the things that would be necessary to take that case all the way through a jury trial. So you agreed to plead guilty, and they give you a bit of a benefit by taking a couple of years off of your sentence. I think that's a very sort of idealized characterization of the way that plea bargaining works in our system. In reality, I think it works much differently. And instead of sort of being given a consideration or an inducement of some kind, I think it's much more accurate in most cases to describe what's happening as naked coercion. So instead of being given some modest inducement, if you'll go ahead and plead guilty, instead what happens is prosecutors have become extraordinarily adept at applying various highly coercive levers to people who are looking, or sort of on the wrong end of a criminal indictment. I'll give you just one example. I read an article recently about a man in Texas who was wrongly accused of molesting a child, a neighbor child. It turned out he did not do it. And he was offered the following deal. If you will plead guilty to some fairly, low-level way of expressing what may have happened here, then the prosecutor will recommend 120 days in jail and a lifetime on the sex offender registry. If you refuse that deal, then we will take you to court, and if we get a conviction, we will press for 99 years in prison. That is not remotely an inducement. That is not remotely, some modest consideration in exchange for pleading guilty. That is outright coercion. And not every case is that bad, but more cases are more like that than the original, kind of highly idealized version that I gave. And so I think, and we can talk about what some of the other coercive levers are that prosecutors are able to apply. But when you think about how valuable a jury trial is to a defendant, even a guilty defendant, just going to trial, and the government has lots of burdens and challenges in a criminal trial, and there's lots of opportunities for the government to drop the ball and fail to get a conviction. You think about how extraordinarily valuable a criminal jury is to both guilty and innocent defendants. The idea that almost nobody would choose to exercise that right is extraordinarily suspicious. And what I think is almost certainly going on is that most people are in fact being coerced into giving up their right to a jury trial, not persuaded with modest inducements the way that prosecutors would have us believe.
Well, so I imagine the argument from the government's perspective is that when people are accepting a plea bargain, whether or not we think it's a fair situation, that ultimately it's a guilty person accepting a plea bargain. Is that true? And sort of how does the factual guilt or innocence of criminal defendants play into the plea bargaining decision?
Well, I think this is one of the most disgraceful elements of our system, and that is it is an open. It's openly acknowledged that that guilty. I'm sorry, factually innocent people routinely plead guilty. There's no question about it. One of the ways we know that, for example, is that the Innocence Project is a nonprofit that uses DNA evidence to exonerate people. DNA evidence is, of course, not perfect, but it's the best that we can get. It's very close to fully reliable. And of the over 300 exonerations that the Innocence Project has obtained since it's been around, 11% of those were people who falsely confessed to crimes that they did not commit and falsely pled guilty to crimes that they did not commit. There are a number of other sources that support that figure and suggest that it may even be low. So a very significant number of people who plead guilty in court are in fact not guilty. And there's a growing body of empirical research that shows that it's actually far easier than you might suppose to induce an innocent person to plead guilty if you apply the right levers. So we have a system that empirically we know for a fact routinely coerces innocent people into pleading guilty. And the collective response of the judiciary and prosecutors is just to shrug their shoulders and pretend as if that doesn't happen, or to maybe engage in some, sort of pro forma hand wringing and then just go on with business as usual.
Well, so I imagine that the phenomenon you described earlier of, threatening someone with effectively life in prison unless they plead guilty, in which case they'll get a relatively short prison term, would be pretty coercive to a defendant and a strong inducement to plead guilty. Are there other tools that prosecutors use in order to increase the attractiveness of taking a plea bargain rather than going to trial?
Oh, absolutely. There's any number of tools that prosecutors have. One of the most powerful is pretrial detention. So a defendant who is locked up awaiting trial is in a much worse position than somebody who is out free, both because being locked up in jail is extremely unpleasant and people will do almost anything to get out, but also because it makes it very difficult to participate in your defense. Makes it hard to find a lawyer, makes it hard to work with that lawyer, makes it hard to find documents, phone numbers, witnesses, and other things that might help your defense. So being able to incarcerate somebody pretrial is an extraordinarily powerful lever that prosecutors have, and many of them make full use of it.
And are there other things that prosecutors do as well? Or like maybe kind of if you could talk a little bit more generally about sort of the different kinds of tools.
Yeah, I mean, so the main things I would say are pretrial detention, what we call charge stacking, which is essentially charging a crime in a way that's sort of much worse than a fair-minded assessment of what really happened, so as to expose the defendant to the highest amount of punishment possible to improve the prosecutor's negotiating position. You can also threaten mandatory minimums. Just to take one example, there's a 1978 Supreme Court case called Borden, Kircher v. Hayes, where a fairly low-level check fraud person was threatened with, well, he was looking at 2 to 10 years. He was offered a 5-year plea deal. He said he didn't want to take it, so the prosecutor said, well, in that case, I'm going to re-indict you as a habitual offender, in which case you'll be looking at a mandatory minimum of life in prison without the possibility of parole. And in fact, the defendant exercised his right to trial, lost, and was sentenced to prison for life. So that's a very powerful tool, is exposing defendants to mandatory minimums. And then there are some informal tools that are really quite sordid, and many prosecutors will effectively deny that this ever happens, but many criminal defense lawyers will tell you they absolutely do. And one of the most horrific ones is threatening a person's friends or family. So, for example, you're a prosecuting person, you want them to plead guilty, they won't do it, and you say something like, well, your kids worked for your company for a few years, maybe we'll take a look at them. Oh, your father owns a landscaping company. Well, do you suppose he ever hired an undocumented worker, or uh, cut corners on his taxes? And so these kinds of overt threats to investigate and or indict family members if somebody will not take a plea, we know that they happen. I mean, for example, it's a matter of record that Monica Lewinsky began talking to the FBI after they threatened her mother with 25 years in prison. So this is very clearly a tool that is used sometimes, and the only question is how often. But it's not just the application of any one of these levers that we should be looking at. It is the aggregate effect of applying these levers together. So the pretrial detention, the charge stacking, the mandatory minimum, possible threats against a person's family and friends. It's the aggregate effect of all of these coercive levers being brought to bear on an individual in a concerted and sort of very unabashed effort to get them to spare the government the expense, inconvenience, and risk of a jury trial and instead confess their guilt.
Well, so are there changes you think we could make, or shifts in the way we structure the plea bargaining system that would make it less coercive, that would limit the ability of prosecutors to force people's hands, and to sort of improve plea bargaining so that it could kind of, at least in theory, potentially come closer to living up to the promise of being a sort of fair compromise between the government and the criminal defendant?
Not really. I don't think so. I think the best you can do is sort of manage it. I think one way to think about plea bargaining is that it's a kind of extremely aggressive cancer, that one of these forms that's very difficult to actually get rid of. The best you can do is kind of beat it into some form of remission and just minimize its effect. Another way to think, of course, of plea bargaining is I think of it as sort of the heroin or the fentanyl of the criminal justice system. It's very, very difficult to get the system. The system is essentially addicted to plea bargaining, and more specifically to coercive plea bargaining. And so I think we have to be very realistic in our assessment of the problem. This is as bad a problem as a system can have. This is literally, coercive plea bargaining is a cancer on the criminal justice system. Now, I don't think that means that it's hopeless. And I think one of the most important things we can do to try to combat uh, coercive plea bargaining, as suggested by the title of my article, is essentially to go back to a founding era version of the criminal jury trial. We've completely transformed the criminal jury as an institution compared to what it was at the founding and what it was for more than 800 years of Anglo common law before that. Essentially, as Akhil Amar wrote in an article, the modern American criminal jury trial is a pale shadow of itself. It is nothing like what it used to be. And one of the reasons I think why people are willing to give up their right to a jury trial, in addition to the coercion that prosecutors have become so adept at applying, is that the institution or the procedure of a criminal jury trial is much less valuable now than it used to be, because judges and prosecutors have invented this myth of the criminal jury as merely and solely a fact finding body. That is a remarkably recent and I would say even cynical invention. That's a myth. That's not the true role of a criminal jury trial in our system historically. It's simply a convenient myth that prosecutors and judges have invented and perpetrated.
Well, so in your paper, you talk about jury empowerment. I wonder if you could talk a little bit about what that means, and sort of what the historical role of the jury was as compared to the role the jury is expected to play today.
Sure. Well, historically in England, criminal juries, seem to have been primarily sentencing bodies. There weren't nearly the sort of volume of criminal prosecutions that we see in America today, and the crimes involved were not, particularly complicated crimes. There were things like homicides, armed robberies, arson, things like that. Seems to be some historical consensus that there generally wasn't that much doubt about the defendant's guilt. But the jury functioned as what you might call a sentencing body, or more specifically, an injustice preventing body. And what the main function of the English jury, criminal jury, was to prevent convictions where the punishment that the government proposes to inflict would be unjust. Most felonies in England up until the middle 1800s were capital, including property crimes above, I think, 40 shillings. And so English juries, which unlike American juries would provide their verdict, they would give a special verdict. In other words, they would answer specific facts about the case. It was not uncommon for an English jury to answer those questions and to respond to that special verdict form in a way that would avoid the imposition of capital punishment if they felt that that would be unjust. This was not only a common but also a well accepted function of the jury in England, and it seems to have been the case also at the founding that there was an understanding that not only a legitimate but indeed an extremely important function of the criminal jury was to prevent tyranny, to prevent injustice by refusing to convict factually guilty defendants if the punishment that the government proposed to inflict would be unjust. That's really what we've lost. That was, I would say, a key feature of the founding era and English pre-American criminal jury, and that's really what we've lost because judges and prosecutors go to extraordinary lengths to try to ensure that jurors are not aware that that's a legitimate function for jurors to play and to deprive them of the information that they would need in order to play that role. So, in a nutshell, what I think would be extremely beneficial in terms of ameliorating the effect of coercive plea bargaining would be a return to founding era informed juries.
So, I mean, it's my impression that, today courts and prosecutors treat the idea that juries would question the legitimacy of a prosecution writ large, or even question the legitimacy of a, the underlying kind of criminal claim against someone, whether or not it's legitimate to prosecute someone for that, as being sort of inappropriate or illegitimate itself. I mean, they use a term like jury nullification and whatnot. And yet it seems like it still happens sometimes. I mean, I'm thinking, like, for example, recently there was the fella who was acquitted for giving food and water to undocumented migrants at the Texas border, where it seems like the factual elements were proven and yet the jury acquitted him anyway, which seems like a version of nullification. Like, how did that shift happen? How did it go from a jury that was expected to judge the legitimacy of punishment and of criminal prosecution to a jury that was discouraged from doing that, or even, like, to the best of their ability, like, prohibited from doing that?
Yeah, it's a great point. And the man was named Scott Warren. DOJ prosecuted him twice for providing aid to migrants in the Arizona desert. The first time the jury deadlocked, the second time they acquitted, despite the fact that he is rather clearly factually guilty. That's a perfect example of so-called jury nullification. By the way, I don't use that term because it is pejorative and inaccurate. Juries don't have the ability to nullify anything. All they can do is acquit a particular defendant in a particular case. And so I think a more accurate description is conscientious acquittal. But putting aside the terminology, the idea, so the America's legal system has a really, frankly, kind of schizophrenic attitude towards so-called jury nullification. On the one hand, the Supreme Court has consistently acknowledged that it is a legitimate feature of the system, and that jurors must never be told that they cannot do it, and must never be told that there could be any consequences if they did it. On the other hand, the Supreme Court has made clear that they should be discouraged in every other possible way from doing it, and it is perfectly permissible to discourage them from doing it, both by suggesting to them that it would be inappropriate, by making sure that the defense counsel never gets to mention the concept of jury nullification. So there's this kind of interesting tension within American jurisprudence. On the one hand, there is a recognition of the fundamental legitimacy of so-called jury nullification, but also a concerted effort on the part of judges and prosecutors to ensure that juries remain ignorant of that institution, and to give prosecutors as much leeway as possible to ensure that anyone who believes in jury nullification, for example, and avows that belief, will not be seated on a jury. I think that is utterly unprincipled and utterly inconsistent with founding era practice. But it's essentially it's sort of evolved more or less organically. There's not some decision where the Supreme Court or any other court, kind of confronts all of this and says, sort of thinking this through and considering all of the relevant arguments, both historical, policy, and otherwise. Here's our conclusion. Here's our conclusion about what we want the system to look like. Instead, it really is just essentially the system kind of organically evolving in the direction of a very strong government preference for a system where the jury will be relatively less valuable to defendants than it was at the founding era, thereby making them relatively more amenable to pressure to forego the jury trial and simply plead guilty, because that really is the ultimate goal of the American criminal justice system at this point, is efficiency and to process as many criminal prosecutions through the system as possible. And the only way to do that is with plea bargaining.
Well, so I know that some people, at least, and certainly courts and prosecutors, are critical of jury nullification or, principled acquittal, conscientious acquittal, for a range of reasons. Do you think any of those reasons for being critical have any purchase? And if not, why not?
Well, I mean, look, the process of adjudicating guilt in a criminal case is an inherently imperfect one, necessarily because it's a human process. All human processes will be imperfect. So it comes down to a question of pick your suite of imperfections. So I'm certainly not saying that I think that a criminal jury that has been informed of the sort of the history of conscientious acquittal and, let's say, the consequences for the defendant if they convict in the particular case that they're impaneled for. I'm not saying I think that's a perfect system. It certainly has some challenges, and I can talk about some of those. But the real question is, compared to what? And if the question is, which is more desirable, what I just described, or a system in which prosecutors have free rein to bring whatever coercive levers are necessary to bear in unreviewable fashion to defendants to get them to plead guilty, I just don't think it's a close call. That being said, there's certainly we've seen results that are sort of difficult to stomach, and I would say a pretty good example of acquittals against the law, or maybe a better way to put it would be acquittals of defendants who appear to be factually guilty that I personally find objectionable, is when juries acquit police officers who've rather clearly abused their authority, have harmed people or even killed people without legal justification. It's very difficult to convict a police officer for the excessive use of force, and we see that time and time again. Michael Slager, the police officer who shot Michael Scott in South Carolina, Slager, I forget his first name. A lot of people don't realize that before he pled guilty in federal court, he had a state court prosecution where his jury deadlocked, notwithstanding the fact that he was on video shooting a man 8 times in the back. So that, to me, would be an undesirable example of a jury failing to acquit or failing to convict a factually guilty defendant. But again, we need to think about the question compared to what, and in terms of the net effect. So yes, it's certainly the case that a jury that has been informed of its power to acquit against the evidence, to engage in conscientious acquittal, may occasionally allow a guilty person to go free who, on balance, should have been convicted and punished. But I think it much more often cuts the other way, namely that properly informed juries are much more likely to protect people from unjust punishments. Let me give you one example. There's an article in New Orleans a few weeks ago where prosecutors had to reduce charges against somebody who they were trying to prosecute for distribution of marijuana because they were unable to impanel a jury that would agree to convict that person. So in other words, people during voir dire were saying, if you prove all those elements of the crime of distribution of marijuana, I still won't vote to convict this person, basically because I think that's a ridiculous thing to be prosecuting somebody for. That's exactly the kind of feedback that our system intended for prosecutors to receive from the community. And by breaking that feedback loop, which they have done by practically eliminating the criminal jury trial, they've really destroyed this extraordinarily important channel of information that was intended to inform not only prosecutors, but legislators what kinds of activity or conduct ordinary people think that the government should or shouldn't be prosecuting.
Well, so in a way, for me, there's a certain sort of Back to the Future quality to what you're proposing, in the sense that it's like looking back to how things used to be done and saying, boy, we really made a terrible mistake at some point in time by losing this kind of institutional check on government power. But like, as a practical matter, how do we kind of revitalize or return to that kind of principle? I mean, like, to your mind, if we were going to move in this direction, how would we implement it most effectively?
Well, the good news is that the entire system that we have now depends on the systematic suppression of information, and in fact of factually accurate information. And our system is not well set up for that. And our history indicates that anytime the government thinks that some policy requires the suppression of factually truthful information, they're almost always wrong. And this is a great example of that. Let me just give you one concrete example. There's a trial going on, a federal prosecution in Connecticut, where the defendant is looking at a mandatory minimum of 15 years for a crime that is, right there in the United States Code. Anybody could look it up in 10 or 15 seconds and ascertain that there is a mandatory minimum of 15 years for this particular crime. When his defense counsel asked the judge to consider informing the jury that the defendant was looking at a 15-year mandatory minimum if the jury voted to convict, the DOJ prosecution team collectively lost their mind. They panicked and immediately filed a motion to stay the trial and sought a mandamus petition in the Second Circuit. Think about how strange that is. The prosecutors in this case are desperate to prevent a jury from knowing what the government already publicly proclaims and is ascertainable to any American with an internet connection in 10 or 15 seconds, namely what the federal government's position is as far as what the punishment should be for this particular conduct. When you have a prosecution team that is desperate to deprive a jury of that information, I think that should really be a signal that there's something very concerning going on here. So the answer to your question is what can be done. It's quite simple. At the defendant's option, in a criminal prosecution, the jury should be advised what the consequences will be for the defendant if they convict, not just the punishment that the government proposes, the formal punishment, but also any collateral consequences like the loss of civil rights or possible deportation. And the basic point here would be that we should go back to the founding era. And it's not just the founding era. This really does go back centuries in English history. Go back to a mindset where the government, not only in a criminal prosecution, the government not only should have to make the factual case for guilt, but also the moral case for the particular punishment that they seek to inflict. And if the government can't do both of those things, then that's a pretty strong indication that that's a case that should never have been prosecuted in the first place.
Yeah, I love it. So, Clark, I know you're working on a lot of other criminal justice reform related projects. I wonder if you could talk briefly about some of those and what they're intended to accomplish.
Well, thanks for that opportunity. I will say this. I've come to the conclusion that the criminal justice system in America is so profoundly broken and so deeply pathological that it really can't be reformed in any meaningful sense of the word. It frankly has to be reset. Uh, and the problems that are in the system and the injustices are, I think, so profound that it's just not a matter of sort of tinkering around the edges, which is all that we've been doing for the past however long. So I think that we really need to think about some fairly radical changes. And one change that I'd like to see, and I'm actually working on this as a kind of a passion project on my own time, is treating any involuntary encounter with law enforcement as a genuinely hazardous situation akin to, a traffic accident or something like that. Police have become so adept at getting people to give up their valuable constitutional rights, their right to be free from unconsented, warrantless searches, their right not to answer potentially inculpatory questions, and so forth. Police are so adept these days at overcoming those rights that I think really nobody should ever speak to a police officer in an involuntary encounter without access to counsel. So I'm trying to figure out a way to provide free, live legal representation to everybody who wants it during any involuntary encounter with law enforcement. And one of the reasons I think that's so important is that if you talk to any criminal defense attorney and ask them what percentage of your clients have already fatally impaired their own defense or their own case before you ever meet them. In my experience, the consensus figure is anywhere between 50 and 80%. So we've allowed a system to arise essentially where government agents are either kind of cajoling or tricking or intimidating people into giving up valuable constitutional rights that makes it virtually impossible to defend them later on down the road. I'd also like to see the end of cash bail. I think that could be achieved. And most of my solutions, by the way, most of my proposals come from outside the system. I believe the system is fundamentally recalcitrant and unwilling to change. And so change needs to be imposed from outside, not requested. So another possibility would be to have philanthropists put up bail money for people who can't afford it, and to systematically, through philanthropy, ensure that no person who's eligible for cash bail remains locked up just because they can't put up the money. I would also revitalize public defenders' offices. The mindset of most public defenders' offices is that they're there to negotiate pleas for most of their clients. I understand why that has to happen. I think we should radically transform that. I want to see the mindset of every public defender's office to be that they will provide the most zealous defense possible for each and every one of their clients, and they need vastly more resources to do that. Again, that could be partly a matter of private philanthropy. And as we discussed a moment ago, I think another important piece of the puzzle is to ensure that people serving on juries are properly and fully informed about not only what the government's trying to do to the defendant in a particular case by way of imposing punishment, but also what techniques they've engaged in an effort to get that person to plead guilty, what kinds of levers they've applied, what kinds of threats they've made. The government should have to acknowledge its conduct in that regard during trial and justify it. And I'm told that in England and some other countries, that's actually a part of the process, but the government has to answer for its investigative and prosecutorial techniques that it has engaged in that case. And I think that would impose significant discipline on the conduct of police and prosecutors in many cases if they knew that they would one day have to go in front of a jury of 12 people and own up to the investigative techniques that they used and the efforts that they've made to induce a plea. And if they're confident that those efforts were non-coercive and legitimate, then they shouldn't have any problem saying to a jury, yep, this is what I did. I think the reason they may be uncomfortable sharing that information with the jury is they understand that it may be deeply offensive to some juries if they find out, for example, that this prosecutor threatened a person's family if the person wouldn't plead guilty. As I say, I think it's really important that they own up to that. And if they think that might look bad later on down the road, that might cause them to stop doing that kind of stuff and stop applying so many coercive levers.
Yeah. Awesome. Well, Clark, thanks so much for coming on the show. And I can't tell you how much I admire the important work you're doing in this area.
My court is in session. Will you please stand? First, allow me to introduce myself. My name is Judge 100 Years. Some people call me Judge Dredd. Now, I am from Ethiopia. Try all you rude boys for shooting black people. In my court, only me talk, cause I'm Bex, and I am the rude boy today. Who got Bex?
Yes, sir.
Rude boy Adolphus Jakes? Yes, sir. Rude boy Emmanuel Zachariah Zaki Palm?
Present.
George Gravenfleet? Present. Adolphus James?
Yes, sir.
I see where you have been charged with 10 shooting with intent, 5 murder charge, 6 grab and flee charge.
But you are not
Hush up! Guilty or not guilty?
Not guilty, sir.
I don't care what they say, take 400 years, stand down. Emmanuel Zachariah Zakipam,
Yes, sir.
you've been charged 15 charge of shooting intent, 15 murder charge, and I heard that you was the one down there in Sutton Street who tell the judge, rude boys don't care. Well, this is King Street, and my name is Judge Dredd, and I don't care. Now take 400 years.
I don't know what you're going to say, you know, Your Honor, because...
Hush up, what they trying to do, shoot me too?
No, Your Honor, but I didn't shoot him.
Well, quiet.
Not somebody, yes, sir.
400 more years for you. George, grab and flee.
Yes, sir.
Stop your crying. Rude boys don't cry, that's what I hear.
I didn't do it, you know, sir. I'm free, man. I don't give you a chance.
I don't care. Hush up. This is my court. You're charged for robbing school children, robbery, aggravation.
Well, man, I take my sentence to you, know, son. You shoot the man, you know. And you say, I'm going to the judge come try, you know, son. I take my sentence to you, know, sir.
Hush up. Order. Adolphus James,
Yes, sir.
you rob school children. You boom the people's house. You shot black people.
But Your Honor, I don't give you.
Hush up. Just for talking, I now charge you for contempt, and that is a separate 100 years. I hereby sentence you to 400 years. I said hush up, hush up. You are sentenced to 400 years and 500 lashes. I am going to set an example. Rude boys, don't cry, don't cry. When I was in Africa, here you were tough.
I'm not guilty,
Put a turn, take them away.